YouTube. Good afternoon, everyone. Welcome to today's session of Only One Theme, which is our awareness talk series on innovation management. I am Dr. Mugdha Lele, and on behalf of the TechX team at Venture Center, I am happy to host the third wave of this talk series on innovation management, which is titled Only One Theme. I welcome to the eighth talk in this wave, and today's topic discusses patent box regimes. And our speakers for today are Ameya Kunte, and he will be joined briefly by also Vasudevan. I'll be briefly introducing both of them. Ameya is the founder of Globeview Advisors, a boutique consulting firm specializing in tax-centric advisory work. With over 21 years of professional experience, Ameya specializes in advising on domestic and cross-border transactions, mergers and acquisition deals, and global transfer pricing, serving diverse clientele across sectors like tech, pharma, IT, real estate, e-commerce, fintech, and EPC. Before founding Globeview, Ameya worked with top firms like Ernst & Young and PwC, and he started his entrepreneurial journey by co-founding Taxsutra, leading B2B tax news and information portal in India, where he served as co-founder and executive editor until 2019. Ameya is a respected speaker at various Indian and global forums on tax. He also serves on board of VRI, an automotive component supplier in a US-India joint venture. He's also active member of committees of the ICAI, the Chamber of Tax Consultants, and other organizations. By training, he is a chartered accountant, a commerce graduate from Pune University, securing top ranks in his examination. Beyond his business ventures, he enjoys teaching at the ILS Law College and is associated with NGO Doorstep School for over 15 years. Our other speaker who's going to join briefly in this session is Mr. Vasudevan. He's a CA and a lawyer. He has over 7 years of experience in international tax transaction advisory work. With this brief introduction, welcoming both Ameya and Vasudevan and handing over the session to them.
Thank you, Mugdha. I hope my audio is clear.
Yeah, it's fine.
Thank you. Dr. Premnath, Mugdha Venture Center team, thank you so much for inviting me to this wonderful series. Compliments to the Venture Center for hosting this series week after week on the topics which are relevant. So thank you, first of all, to you for this opportunity. I also welcome all the online participants, all the online AI note takers, which I can see who have joined the call too. And also, I think wonderful students attending the session via the conference room at Venture Center. So, good afternoon, good evening to all of you. Uh, as Mugdha mentioned, we will be discussing the topic of patent box regime. And on the face of it, the name patent box does sound very complex, complicated. It sounds a bit fancy, possibly as well. Uh, it's essentially a tax provision which is present in India and in several other countries. And we are going to sort of, over the next 50 minutes or so, explain you through some of the nuances which are there in the Indian patent box regime, what it is, what are the features, what are the benefits, and how it can practically be applied in certain situations. And there are certain major policy limitations that we have with this regime. So we have got few slides, and me and my colleague Vasudevan are going to discuss through these slides over next 50 minutes. Mugdha, just wanted to again recheck if my slide is visible and if my audio is clear.
Yes, Amay. It's
Okay,
clear.
super. Thank you, Dr. Premnath. Good to see you. I know Dr. Premnath is extremely passionate about this subject as well. My request to all the participants who are joining via Zoom, if they have any questions on a topic, try and put your questions in the chat window itself. And as we sort of progress at a suitable time, I'll take pause and try and deal with the questions as and when we sort of as and when they come up, rather than waiting at the end, so that relevant issues could be discussed then and there itself. So, why patent box, or what is patent box? At a very conceptual level, it is a concessional tax regime on the income which is derived from the intellectual property, particularly the patents in the Indian context. So just to step back, there are many sort of people who may not, I mean, just to set the basic context, tax is applicable on the profits that any business generates, or if a scientist develops a sort of a molecule or a patent and registers, and also earns the income from any of the activities, a company or such an individual is required to pay the tax. As you know, the headline corporate tax rate in India is 30% plus surcharge. If a company has opted for a new regime, it's a 25% headline corporate tax rate. And for a individual, the highest personal tax rate is about 43%. So whatever profit or income you earn, you end up paying tax on it. But the tax law provides an incentive regime wherein specified income is reduced from the headline tax rate to a lower tax rate. Patent box is one such regime or an example. Special economic zones in India is another such example where there is a tax incentive through which your effective tax rate is reduced or can be brought down to nil. So patent box regime in India reduces the tax from your headline tax rate of 25%, 30% to a 10% rate, provided you meet several conditions. And what is the objective? The objective is that you want to promote the research and development in the country. And there are various ways in which government can make a policy intervention to promote the research and development. So the startup program and various incentives is one aspect of it. Uh, you know, there could be certain sort of direct fiscal incentives that government may provide on certain research and development projects through grants. That's another way the incentive can be given. Uh, the other way, which is there, is to through the tax policy, wherein whatever is a normal corporate tax that a company has to pay, that is reduced, and in a way, it sort of incentivizes a company to uh, use that saving for carrying out the research and development. I mean, that's really the policy initiative. Uh, Idea being to encourage research and development in the country. I must step back and also give a slightly broad policy view. Over the last 7, 8 years, India at least has reduced the dependence on the tax law to provide the fiscal incentives, and India is moving to a situation where they provide the incentives directly to the beneficiary or activity. PLI scheme is one example where the incentive is given directly and not indirectly. And patent box to a certain extent remains an exception to this policy, and it is still a benefit which is available, providing a lower corporate tax rate on the IP-driven income. So that's really very, very a sort of a basic context uh, to what we are going to see. So over the next few slides, we will now get into what is that patent box regime, what are the conditions, who's eligible, who's not eligible, and what is really the benefit from the patent box regime. Essentially, it brings down my tax liability. I think that's a sort of simple one-line answer. Uh, I'm going to now move to the next slide, which is what are the key features of this patent box. And my colleague Vasudevan will quickly explain some of the key conditions on the Indian patent box regime, just for you to get a better idea. Vasu, over to you. You are mute. Yeah.
Uh, Thank you, Ameya, Dr. Pranath, and Mukta, and also the Venture Center team for this opportunity to speak with all of you. And very good afternoon. Like Ameya mentioned, the very idea of having a patent or an intellectual property is to incentivize uh, research, incentivize development, incentivize novelty. So patent of all is one of the most, which has to pass through the rigors of being something very novel. And the Indian tax administration has considered the eligibility on patent-based income uh, for a lower tax outflow, so that the net income that is remaining with the person who's doing the R&D is slightly higher. So, now let us look into what are the specifics of this regime that the government has given. So, as a matter of fact, before we start, the response to this regime has not been too great in terms of how people have taken it or how people have benefited. But there are still some good amount of benefit, and we'll see in further slides as to what different challenges also that we are facing. And to give that context, it will be good to see what are the benefits and the restrictions attached to the Indian patent box regime. So quickly seeing what is eligible for a patent box regime is the income that is arising from a patent. Now, what is covered is only a patent and not any other IP that you hold. And within the income also that is eligible for a lower tax rate, it's only the royalty income. And there is a clear-cut explanation of what royalty means. But what can be said is that if you're using the patent for in-house development of a product or a technology, and you earn income out of that as a service income or a sales income, you're not eligible for a patent box regime. It's more of a royalty income that is allowed a patent box regime in India specifically. And what really is the benefit in terms of numbers is that on the royalty income that you earn from the patent, you will have to pay a tax of 10% plus surcharge and cess. So instead of 22% plus surcharge and cess, you essentially bring down the tax rate to 10% plus surcharge and cess. So that delta of 12% is really the benefit. Well, alt is a benefit that you're getting by going into the patent box regime. And another important aspect is it's a gross based tax. Gross means the whole royalty income will be subject to 10% tax rate, and any connected expenditure that you are incurring for earning that royalty income, you will not be allowed any deduction of that expenditure. So as a general principle, there is a reduction of expenditure that you incur for computing what is your taxable income or business income. But in case of royalty, which is eligible for patent box, you will not be allowed any expenditure reduction. But on gross level, there is a reduction in the tax rate. And as the idea behind this patent box regime was to create a good, or was to give an impetus to Indian researcher to carry out research in India. Sorry, Ameya, I'm not able to see the screen.
Yeah, we just lost the slides. If you can share it again.
Yes. I'm not sure if Ameya also got disconnected. I'll share at my end. Maybe we
Yeah.
can.
Yeah. Maybe he disconnected. Yeah.
Yes, possibly. Just let me know if my slides are
Yeah, we
visible.
can see your slides. You just need to go full screen.
Sure. Is it fine now?
Yeah. Good.
It's full
Sure.
screen now.
Yeah. So since the idea of having a patent box regime was to, incentivize Indian researchers to carry out research in India, you will see that, the requirement is that the person who is availing the patent box regime has to be resident in India and has to be a patentee. So patentee is the one, generally as we understand, patentee is the one who is given the patent or is allowed the patent. Now, for tax purposes, the patentee definition has been narrowed down to just the true and first inventor. In the patent law, the definition of a patent is slightly broader, which we will see a bit later, beyond who's a true and first inventor. But for tax purpose, only a true and first inventor is eligible to take the tax benefit. Now, who is a true and first inventor? So, as we all understand, this is mostly the person who is inventing, since the patent itself is a outcome of human brain. So one can say it's just the individuals and nobody else who can take the benefit of, who can be a true and first inventor. Therefore, one of the inference that you get from here is that it's only the individual who are eligible for a patent box regime or the lower tax. Another important and a very, very difficult at times, it could be possible, but a important condition is that patent must be developed and registered in India. Developed and registered, it is fine to say it has to be developed in India, and registration is very obvious that you have to register the patent in Indian in the Indian patent registry. But the developed as a word requires you to incur at least 75% of the development expenditure in India. So most of all that you're paying has to be paid within India. So this might, in a way, mean that if you're doing testing, or if you're incurring certain expenditure from in the foreign jurisdiction to get certain services, which will enable you to develop this patent, that becomes a bit difficult if you're incurring more than 25% outside of India. So the threshold is up to 75% expenditure to be incurred in India and not outside. So these conditions are, other key, requisite that you need to fulfill in order to avail the beneficial tax regime under the Indian tax system. Yeah. So I'll just see if maybe Ameya can take up the next slide. We'll just see if it's
Vasu,
available.
can you explain this 75% expenditure incurred in India again, saying which expenditure are we talking about, from where?
Sure. So the 75% expenditure is that all the expenditure in developing the patent. So all your research expenditure, it might be for all the services that you're availing for, or all the material that you're procuring to carry out your research. So it depends on what kind of research you're doing for the patent. But the 75% expenditure basically means of all the expenditure that you've incurred in developing this patent, 75% has to be paid within India and should not be paid outside. So now testing is, just to give an example, in most cases testing, especially take a pharma example where the medicine has to be tested elsewhere. Probably you don't have enough infrastructure in India to do a clinical trial or clinical testing. And then if you send the medicine outside of India, spend a good amount to have a proper clinical trial done on a particular medicine, then if that expenditure that you have incurred is exceeding 25% of your total expenditure in the development, then perhaps you will not be able to avail the benefit of patent box regime. This is definitely onerous in terms of how how much one has to really restrict the expenditure in India itself and not spend outside. So at times it can be difficult, but that's where the condition currently is stated and might be up for some kind of relaxation, hopefully.
At this stage, can I just ask one more question, which is,
Yes, sir.
tell us, is this patent box regime equivalent available in other countries also? And if so, how does it look different? And because there will be companies, there will be inventors who will file in other countries as well. So is such a system available in other countries, and how does it differ?
Sure, sir. So there are parallel systems available in multiple countries, and most of these countries also require you to incur some amount of expenditure in that country, but they do not say that if you don't incur so much expenditure, we will not allow you any benefit at all. Rather, how they place their patent box regime is that to the extent of your expenditure that you are incurring in a particular country, the income is also allowed for lower tax rate to that proportion. Suppose, just to give an example, if you spend 100 rupees in development of a patent, which you are registering in, say Ireland, just to give an example, if you have spent overall 100 rupees in development, out of that 50 rupee was paid in Ireland itself for development and 50 rupees in elsewhere. Now, if the patent which is registered in Ireland is generating an income of 1,000 rupees, the income which will be eligible for a patent box regime will be only 500 because 50% of the expenditure was incurred in Ireland and not more. So it is the patent box regime is restricted to the expenditure that you incur in a particular jurisdiction. But there is no condition which says if you have not incurred so much expenditure, there is no patent box regime available to you at all. So that's how other countries have worded their patent box regime, whereas India has put this condition of 75% expenditure incurred in India, otherwise no patent box regime. And there's a bit more in detail that we'll look into the comparative positions between India and other countries later in the slides also, which will again explain and take more examples of particular or specific countries there. So does that answer your question, sir?
Yeah, please continue. Yeah, thanks.
There was one question in the chat box about the institutions. What would be their status? Institutions or academics that own the patent?
Sure. So per se, I believe under the patent law, if they are considered as 21st inventor, it's only then that someone is eligible for a patent box regime, and there can be questions on whether those academic institutions are mere assignee or they are true and first inventor. If they are just assignee, then it is difficult to get the patent box regime, is my thought. I'll leave it to Ameya also if he has something to add over there.
Sure, thank you. As I mentioned at the beginning, there is a larger sort of policy relook which is needed around the patent box regime, and today the interpretation around true and first inventor in the context of patent law, and can that be differently looked at for the context of tax law is a issue, and therefore it creates a huge uncertainty. Uh, Based on the literal reading of the law, it's not available if you're not a true and first patenter, true and sort of first innovator in that sense. So that is a bit of a limitation today. So we'll move on, Vasu, to the next part.
Moving the slides.
Sure. I think it's
It's not full screen right now.
yeah.
Ameya, just a quick question. In other countries, have they defined it differently in who's eligible?
So again, answer is yes. Who is eligible is defined. If you're merely acquiring a patent and then sort of commercially exploiting it, then of course it is in such a case uh, the patent box regime doesn't apply, because idea is that you should be actually carrying out the innovation and R&D in the jurisdiction to be able to get the benefit, and not merely commercially sort of exploiting it per se. But this sort of narrow perspective around uh, the original innovator, the way it is, and it is coming partly from the patent law and borrowed into the tax law, is not there. So to give an example, Dr. Premnath, which is common in many companies. Let's say there is a pharma company, and a scientist in the pharma company works on a patent. Most of the times, the right from day zero, day one, when that scientist has joined the company as, let's say, as an employee, the company has really funded it, really has provided all the necessary ecosystem to make it happen, and so on, so forth. And company could also be part of the application, but it is really not a true and first inventor. And therefore, in India, it would be difficult for such a company to claim a tax benefit. But most of the other regimes, uh, progressive regimes, do recognize this, reality, as well.
Okay.
Sure.
Thanks.
Thank you.
Ameya, just a quick question. In other countries, have they defined it differently in who's eligible?
Sure.
Or Okay, I think that's, please continue. I don't want to
No,
delay
no,
your.
appreciate. No, no, they appreciate. All these questions are relevant. As Vasu mentioned, in the earlier slide, uh, you will get a patent box regime or a benefit only if it is. So there are now several aspects that we will sort of dissect, and one of the key aspect is a patent. And just to step back, there could be different types of intellectual properties. If I write a book, I get a copyright in it. If I create a movie, I get a copyright in it. It is also a form of a intellectual property. There is a brand, and I license out that brand. That brand is also an intellectual property. Uh, do I get a patent box benefit on such IP, income from such IP? The answer is no. The patent box benefit is available only in respect of income from patents. And as we know, in India, there is a patent law, and patent is available for an invention. And there's a definition of an invention and a whole lot jurisprudence under the patent law on what amounts to an invention. We are not getting into that, but assuming what you have done is eligible for registration as a patent, then who can register is really the true and first inventor, generally a natural person and eligible for patent box. The assignee, under the patent law can also sort of be part of the patent, but for tax law, the assignee is not eligible for a patent box relief. And the patent law says that legal representative of work can also register, and then the patent law provides really the protection in India and enables the international filing of the patent. Now, one key aspect that I want to sort of highlight, and this is even relevant for the students who are law students and attending this gathering, is that in India, let's say most of the scientific inventions are covered by patent, but the computer software is not covered by the patent under the patent law. The protection for computer software is really received under the copyright law and not a patent law. Now, this makes an interesting sort of point that if I develop a computer software, uh, I can't file a patent for it technically, and therefore any IP licensing income is not therefore eligible for patent box. That's point one. Uh, so this is one aspect. Globally, computer software which is similar to the other IP invention is explicitly recognized as eligible for patent box, and that's again one aspect where India is different. Uh, However, again, I'm not a patent lawyer, but if you talk to patent lawyers, even in the computer software program, there are certain aspects which can be subject to patent. So, for example, the systems or the methods. And this is really relevant in the context of today's innovation or the IP, which is AI driven, artificial intelligence driven, where there one can really patent the methods or the systems and not the software itself. And the IP licensing of this aspect can be done under the patent law, or the patent registration for this aspect is something which is possible. So it's a bit of a nuanced aspect. To summarize, uh, patent box benefit is available only for IP which can be registered as patent. Software on the face of it is not covered by the patent law, but it is protected by the copyright law. So that's a brief aspect and an important aspect as well. And with this context, what Vasu explained and what we discussed now, let's see a few examples. And you might be wondering that Amey is already speaking for 30 minutes. There are so many benefits, but so many exceptions. So in which situation really the benefit is available? So if you can see on the left-hand side, Mr. X is a patentee, and there's a Singapore company, for which Mr. X is working, and uh, Singapore company to so X has licensed the so X and Singapore One have jointly developed the patent. Uh, Mr. X has registered this patent in India, and you know he has licensed it to Singapore company too. Even SG1 has licensed it to SG2, a Singapore company too. In this case, most of the tests that we saw on slide 2 are satisfied that Mr. X is a true and original inventor. He has registered a patent along with SG1, but he's also registered it, and he's deriving the patent revenue or the licensing revenue from the Singapore company. And for Mr. X's share, he will be eligible for the patent box regime. Now, let's look at the second example, which is really the situation in most of the business situations in the Indian context is that you have an Indian company, there's an inventor or an employee or a senior person or even a promoter for that matter, and the patent from day zero is assigned to the Indian company. I mean, all the work, etc. And then thereafter, once the patent is registered, Indian company derives a licensing revenue, uh, you know, wherever from Indian client or overseas client. In this case, Indian company is not eligible for the patent box benefit because it is receiving the income from a Singapore company on a patent for which it is not a true and a first inventor. So this is sort of one limitation. Let's look at a couple of other situations and then we can pause and some questions as well. Now, uh, now let's look at a situation where Mr. X and a Singapore company, which are jointly developing the patent. Singapore company is uh, is really incurring and bearing all the expenses on the patent development, which is really then outside of India. Uh, Patent is, let's say, registered in India in the name of Mr. X as well as a Singapore company. Singapore company is commercially exploiting and receiving the royalty income from any customer. So here there are two aspects. Of course, the royalty income is received by Singapore company one. Uh, Mr. X, let's assume, is also receiving part of that royalty. But here, most of the R&D expenditure has happened outside of India, and therefore it is not uh, satisfying the patent box regime criteria of 75% expenditure being incurred in India. So this is sort of one scenario. The other scenario is uh, Mr. X, the patentee, is developed a patent. He does a licensing to the Indian company. So this is example one or transaction one. Now, transaction two is that Indian company further licenses out to the Singapore company and earns the licensing revenues from the Singapore company. So there's a transaction one where Indian company earns licensing income from Singapore company, and transaction two where Indian company pays to the patentee the license fee. Now, in this case, Singapore company paying to the Indian company uh, is not covered by the patent box regime. So Indian company will not get the benefit of patent box, but Mr. X, who's receiving this consideration from licensing, will be eligible for a patent box regime on the royalty income. Um, so practically, so these are some of the conceptual examples that we wanted to just explain the point. Practically, the scenario that we saw on the right-hand side of the slide rarely happens because IP, both the investors as well as the stakeholders would want the IP to be housed in a company and not really no one will want the IP to remain in the hands of the original inventor just to take the benefit of the patent box regime because there is a larger sort of commercial aspect over here. So this is a sort of conceptual framework. Let me now address a few of the questions that have come in the chat box. Uh, so, royalty shared by an academic institute to the professor covered under the patent box regime, will the academic inventor get the benefit of the tax relief? So, the individual professor, yes, I think he will get the benefit of the tax relief as well, conceptually over here. Uh, I'm just reading the questions as well, so allow me a moment. Yeah. So it's an interesting question from Indrajit. First inventor registers his patent in India. He demands a lump sum as a license fee and percentage of profits generated as royalty. And what sort of patent box relief will be available. Now here uh, we will have to demarcate it into here on the face of it, if the first inventor is selling off the the patent or the IP in toto, uh, uh, and sort of relinquishing all his rights in the patent, then this transaction is classified in a way as a capital gain transaction, and the definition of royalty under the patent box rules specifically carves out capital gain transactions. But alternatively, if the inventor sort of assigns significant rights uh, to a commercial entity, receives a upfront sort of license fee, a lump sum license fee, and a percentage based on profit as well. Uh, as long as the first inventor still remains a IP owner or a patent owner, in my view, the patent box benefit is available to him on both the streams of income. Like I said here, I think the legal agreement around the extent of the assignment plays a key role, that this should not become a subject of capital gains itself. So this is a key sort of aspect. There's a question from Dinesh on royalty from foreign patents. Will it be covered by the Indian patent box regime? Answer is no. It is really the uh, patent should be. So, okay, let me just step back. Um, the patent is first registered in India, and then it is registered in the overseas jurisdiction as well. And the Indian inventor is receiving the royalty income uh, from the foreign jurisdictions. Answer is no. He will not be able to. That royalty stream will not be subject to a sort of patent box benefit. So this is really it. Therefore, leaves the regime a bit, like I said, inadequate for the current sort of demands. What is the definition of the royalty? And we will actually see in the next slide certain aspects of the royalty definition given in the tax law. So I'm sort of moving to the next slide. Patentee definition, we already saw it sort of is a bit narrow in the Indian context. Uh, let's look at now the royalty income definition. If you can see the second bucket next to the orange line, royalty income, uh, it includes a consideration for transfer of all or any rights in the patent, imparting of the information on working or use of the patent, or rendering of any of the services. So these three, four limbs are covered. So there's more than conventional royalty. Even services around this IP is also subject to patent box. But like I said, there are two exceptions which are given. Income generated from the in-house use of the patent in manufacturing is not subject to patent box. Of course, because there is no patent income stream which is coming, or income from sale of patent is covered by capital gains and it's not covered by the patent box regime. So this is the definition around the royalty income. Um, the next aspect, which sort of Vasu touched upon, is the Indian definition, where it says that 75% of the development expenditure must be incurred in India. Now this is a key aspect. Now 75% of expenditure, so the qualifying expenditure, that is numerator, is clear. What goes in denominator is also a bit of a gray area. Should you look at the total R&D cost? Within total R&D cost also, should you, for example, load the capex, uh, you know, um, uh, so those are some of the calculation related issues that may also come up. Uh, the other aspect is that the expenditure must be incurred in India, and this is where I was recently talking to Dr. Premnath. He too was mentioning that there are certain sectors in India where you have to go outside of India for completing your IP development, because in India you don't have enough sort of infrastructure to complete certain aspects of the IP development, in which case you might end up incurring expenditure outside of India and breach the 75% threshold. Uh, if you if you if you do breach, then unfortunately patent box regime will not be available. Uh, just to step back, OECD and most of the countries have given guidance on what is included, what is excluded. For example, if you borrow money for the IP development, the interest cost on borrowing is not part of the is not part of the denominator, and therefore it's beneficial to the R&D company. So this is sort of again one more critical area or an issue with the Indian patent box regime. Let me move to the next slide, and then I'll take the questions on this aspect. As Vasu already mentioned, it's 10% of the gross royalty income. So any direct expenditure around royalty, we are not talking about the R&D development expenditure itself, but but against the ongoing income stream, if there is any expenditure, you will not get a tax deduction for this expenditure. Now, this again becomes a bit of a point whether 25% of net profit after expenditure is more beneficial, or 10% patent box regime on a gross basis is more beneficial. Some math will have to be really worked out on this basis. Um, Patents registered in India is what is covered under the patent box regime. Uh, if the patent is simultaneously registered outside of India, does it disentitle? There is a bit of ambiguity on this aspect. But once the patent is first registered in India and you earn the licensing income from it, it is subject to it is covered under the patent box regime. Uh, and the last point on this issue is around the disqualification. I mentioned to you earlier that 10% patent box regime, no expenditure deduction. So the tax law says that the opt-in, opt-out is not possible. So you may have in year one uh, a normal tax rate regime of 25% after net profit beneficial, and then the next year maybe the patent box is beneficial. The law says that if you opt out of the patent box benefit, so you claim in year two, in year three again you go back to the regular regime for 5 years, then you are forbidden to claim the patent box benefit. So essentially, uh, uh, once you sort of start claiming patent box benefit, you can't. If you come out of it, you can't again go back. That's really the opt-in, opt-out restriction which is put up in the tax law. Vasu, do you want to add anything? And in the meantime, let me take a look at the questions in the chat box.
Sure, Ameya. So, Per se, most of these are, covered, and we saw the summary form of what is a PBR regime, and then the intricacies that you just mentioned. So not much at my end to add. Just there are a few. I think I was also looking at those questions, and those are connected to these points that we just discussed. So maybe we can directly move to that
Yeah.
itself.
So there's a conceptual question on, is patent box against the globalization? Answer is no, because I mean, you know, you if you don't take that benefit, you can still be global and but pay the normal corporate tax of 25%. Like I said, it is not be it doesn't act against the globalization, but it certainly acts against the interest of promoting the R&D in India, for sure. Um, can I applicant of the Yeah, so we've already answered these questions. Yeah. So there's a question on, if the true and first inventor is individual, how could he justify 75% development criteria? I think uh, it would be relatively easy for him, because most of the expenditure that he would incur would be in India conceptually, and therefore, in my mind, it is relatively easier. In fact, if I step back, when the lawmakers were drafting these patent box rules, they picked up certain aspects around this development expenditure, but really did not expand on the definition of who's eligible. And the assignee should have been covered, um or the co-applicant should have been covered in the patent box regime. Only then everything else, for example, 75% R&D, probably makes sense as well. Can MNCs with R&D labs and filing patents in India get any tax benefits? So, uh, Indian company is still a resident of India, and if the MNC chooses to do a patent filing in India and receives his income stream, then yes, theoretically you would be eligible, MNC would be eligible. But this is a question from Dr. Premnath. I have uh, I have not seen MNCs wanting to really keep the R&D in India. Most of the R&Ds in India are from the captive units, and they really render the services to the global to the R&D hub or IP holding company, and not really Indian captives are not really the IP owners, so to speak. There are two, three reasons. One is, of course, the most important is the commercial aspect and the IP protection. The second all aspect is also the tax regime is not very, very conducive. I mean, we saw all these limitations. You may be better off putting your IP at a hub, let's say like a Singapore or a UAE or a Ireland, and earn sort of income without getting stuck with FEMA and tax and legal uncertainty as well. But theoretically, if they even a MNC, if it is carrying out R&D in India through its own subsidiary, which becomes a resident of India and files for patent in India, it will be eligible for a patent box regime. Um, so I'll move on to the uh, to the next sort of aspect. Like I said, to summarize, most of the points we've already discussed over here is that the true and first inventor is how the tax law is worded, and it's very restrictive. 75% of the development expenditure in India. Um, Third is the true and first inventor needs to earn royalty. The royalty definition is also we saw it's reasonably broad but doesn't cover the outright sale. And then 10% is a rate. Uh, there are 2 points over here. The last bullet is sort of very, very relevant, and this is a slightly heavy concept around the tax, is the concept of transfer pricing. So if I'm a Indian company, everything in India, uh, and selling or receiving royalty income only in India, this is all good. But if I'm a company with a IP, so let's break it down into two aspects. The first aspect, which is easier and which is most of the times happening, where the foreign MNCs have R&D labs in India. Uh, the way they have structured their transfer pricing, the R&D lab will always be remunerated on a cost plus basis, and therefore that R&D lab will never be in a sense the true and it will never be an IP owner. It's never classified as an IP owner, because otherwise it would mean that the Indian hub needs to be remunerated more. It means that the MNC has to put more profits in India, which most MNCs don't want. So transfer pricing becomes a very crucial role. Similarly, in the Indian context, if an Indian company is doing most of the R&D in India, you cannot artificially shift the IP out of India, because otherwise transfer pricing will also be a sort of important aspect from a tax point of view. So along with your patent box benefit, you also have to look into the transfer pricing model of the group, and finally, where do you want the value to sort of get captured? Should it be in India or should it be outside of India? So these are the multiple sort of factors that will play a role. And in my mind, honestly, a 10% tax benefit is therefore not really on top of anyone's mind. I mean, IP protection followed by the commercial opportunity to exploit this IP, followed by transfer pricing. These are the three majority criteria, and then, by the way, the patent box can also come, and which is why you may also look at some other jurisdiction meet the patent box regime over there, and you may be encouraged to register IP over there. So this is really the combined effect uh, of patent sort of revenues that one has to consider. Let me move to the next slide. Uh, Dr. Premnath, I think you were referring to this point, and this slide summarizes a few jurisdictions: USA, UK, Singapore, Switzerland, UAE, Ireland. We've chosen these jurisdictions. What is the next column is a normal headline tax rate. For example, in UK, it's 25%. In Singapore, it's 17%. In UAE, it's 9%. And what does their patent box regime look like? And again, here, idea is just to give a flavor of it. Uh, uh, you know, Today we will not get into very nuanced comparison of each of these patent box regimes, but USA doesn't provide patent box, but they provide what is known as a benefit through a R&D tax credit. It means that whatever actual expenditure you incur on R&D, you get a you get a tax credit which you can utilize. So effectively, it brings down your cost of R&D in India. By the way, in India also there was a weighted deduction for R&D in certain sectors. Like if you spend 100 rupees, you will get a tax break of 200, for example, or a 400 uh, in the tax law. But all of those have phased out in line with government's policy intention that they want to reduce the taxation as a measure to provide the tax benefits, and it can be given possibly through direct sort of measures. Um, UK, there is a patent box regime, 10% rate, similar to India. Patent and patent equivalent rights are covered. So, for example, software is patent equivalent and it's covered in the UK patent box regime. Nexus principle, which Vasu articulated, is there in UK as well. And you will see Singapore, Ireland also, there's a similar sort of concept. Interesting is UAE that they provide a sort of very attractive rate. I mean, there's sort of exemption which is given, but I must sort of add that UAE has also significantly transformed over the last 10 years. Gone are the days where you can set up a paper box company, artificially put the contracts in that company without people, without scientists, and do an R&D and earn a patent box sort of benefit. there has to be enough substance as well conceptually. That's what even UAE has gone, but it's a sort of very attractive regime which they have provided for. Um, this is a uh, sort of last slide for the discussion today evening, and thereafter we can take the questions. Um, uh, GCCs, Global Capacity Centers, in the last 3-4 years, there is a significant increase in GCCs. Uh, Dr. Premnath asked a question on the R&D labs. As I see, most of these GCCs are really supporting the head office or a IP office or whatever, IP head office, and really not meant to be the owners of the IP. And to that extent, therefore, um, uh, even though GCCs are coming up, the patent box regime, whether it will really translate into a meaningful benefit, I have my doubt. In my mind, with the current framework, not just because of tax, it patent box may not. There be few takers of patent box regime as well. Scientists, of course, this is very much relevant, innovators, and we saw a number of questions in the last 50-55 minutes. For them, the patent box regime is certainly available, and from the highest 40% tax rate, it can come down to 10% plus surcharge, kind of a rate on the patent box under the patent box regime. Um, as far as the startups are concerned, uh, certainly, I think the benefits under the startup law are more interesting around the patents. Within all of these limitations, uh, so there is no separate regime within patent box which is carved out for startups. So if a startup also meets the patent box criteria, only then the benefit is available, and then the uh, the the entrepreneurs or the traditional businesses, I think some models which meet the commercial requirement and the patent box will have to be created. And we saw a few examples where it may be possible, but like I said, practically implementing such models, then patent box becomes a secondary aspect. I mean, because you would want a value unlocking to be a priority. And IP professionals, from their point of view, and legal students who are attending this, uh, there's a close interaction between the tax law and patent box regime and the IP law. What is patent? Whether a AI agent that I've developed, can it fall under the patent, and therefore can I get the patent box benefit from it? These are some of the aspects which will be relevant for the IP professional when he's looking at the patent box law, because tax law actually refers to the patent law. Uh, so you will look at an interpretation under the patent law while applying it to the tax law. And to that extent, this tax benefit is relevant for the IP professionals. Uh, so, uh, so, so I'll pause here and, like I said, happy to take any questions as well. Yeah, I have noted questions from Indrajit. If there are others, feel free to put the questions as well. Let me try to address some of the questions that have come. Is there any income ceiling beyond which 10% regime is no longer applicable? There is no upper limit provided for it. So whatever you get is covered by 10% rate, which is why I mentioned that it brings down your personal tax rate from 43% to 10% uh, for sure. And to that extent, it is attractive for such an individual. Uh, Dr. Premnath, any questions? Uh, so happy to take them as well.
Before we take more questions, let me alert the attendees. There's the feedback link for this talk in the chat box. Please give your feedback before you leave this session. Yeah, over to you, Dr. Premnath.
No, I was just curious about why this name came about, why patent box. So I sort of Googled it to check what was the issue. And it turns out that Ireland started this process, and it there was a box to tick in the tax form, so it got its name of patent box. Interesting. But one of the things which I also learned is that Ireland has been able to attract a lot of companies and their R&D activities here, right? In Ireland, thanks to the patent box regime. So this is just a discussion from the policy point of view. What do you think? Will it help bring more R&D activities to India? How is it that it is a helpful concept?
So just to step back, what Ireland did really well, and which is why, you see companies like even Apple and so on went to Ireland for IP revenues, is that back in 90s they issued private rulings, around patent revenues and said that bring the money in Ireland and we'll offer a almost zero tax. Uh, Even if there is no substantial activity, there have been uh, some litigation that EU is doing with Ireland for those past cases. But thereafter, then came the era where, just with the paper entities and tax exemption, uh, is not acceptable. And today, I think almost no country is able to offer such a regime, because then the global framework, that is OECD, will call it as a harmful regime. And since they last 20 years, OECD has been closely monitoring any such regime that countries introduce. So that's one policy side. The second aspect, to address Dr. Premnath, your question, I think tax is one of it is important aspect, very much relevant, but I think the larger ecosystem around R&D is more of a priority. And I think India as a country, there is a bit of a distance to be covered on this aspect. I mean, I personally really like the PLI. Of course, it went to the larger players, but it's direct. You're assessing the benefit, and you're assessing the impact and giving the benefit. When it comes to the tax policy, the person who's going to look at the tax exemption is a tax officer who may or may not understand really what is a patent, what is a benefit, and therefore administering this incentive through a tax policy, in my view, may not be the most effective way. You could pass on some credits or whatever from a policy standpoint. That's my personal view. But tax can play a role. Uh, but before that, a lot of other things probably need to happen. That's my honest feedback.
Um, I think as of now, it seems that it is tilted towards individual inventors, the way it is set up.
That's right.
If you imagine a country like Sweden, which has the so-called professor's privilege, where the ownership of the IP rests with individuals and not with the institutes, right? I can see that there will be sort of a clear benefit over there, right? Rather than necessarily here. It is still a little ambiguous in some ways. Yeah, but it's meant to probably promote inventors who are carrying home any royalty returns as income and are taxed as income tax on income rather than on profits, in a manner of speaking. At least the strictest definition of the policy, right?
That's
So
right.
but if one wants to promote more, technology development and licensing, then one should take a larger view of it, probably in terms of uh, anybody who licenses it and so on. Yeah. So anyway, thank you.
Absolutely.
Those are very useful points and discussions. I think it's a broader use, and also I do know that there are companies who are interested in seeing it happen, so that a lot more GCCs do their R&D in India, and that is something which is also a wish. But let's see how things shape up. Any other questions which you have missed out from here? I'm sorry, I wasn't following all the questions here. Did you want to take any more questions here online?
Happy to. I think I I I sort of covered. Uh, we've addressed most of the questions, or all of
Okay.
the questions, in fact. So yeah.
Okay, so this video will be available online through the YouTube site of Only One Theme. So people who want to refer to it are welcome to refer to it as well. And I think over to you, Mugdha. So thank you very much, Amay, and thank you, Vasudevan, for this very useful uh, talk and also introducing us to this concept, which was very unfamiliar to many of us.
Yeah, thank you so much, Ameya and Vasu, for joining us for this talk. And let me alert the attendees online. Please fill up the feedback form. We do share feedback with our speakers also. And we are now going to take a small pause in the series till we will have our next talk in the series on 7th of Jan now in the new year. Sorry, I think I mentioned 7 Jan 2024. It is 7 Jan 2025. So happy festive season to all of you. Have a nice year end. And we will see you all in the new year on Tuesday, 7th of Jan 2025. Thank you.
Thank you.
Thanks,
Thank
bye.
you.